I'm Elise Rosemarin. I'm a Senior Vice President here at AKAM. Today, we're going to be discussing the application process, new regulations to be aware of. A few weeks ago, we discussed the fair housing laws and how things have changed. So this is kind of building upon that idea. Joining me today, I have a wonderful professional colleague, Daniel Finger, who is a partner at Finger & Finger. He's an attorney at law. Jennifer Manghisi, who is our Vice President of Transfers and Closings, and myself. As usual, we encourage you to ask questions in the Q&A box, when we will try to respond to them as the questions come up. And then once we are done, and if you're watching this after the fact, we're happy to share information, and you can reach out to Daniel or Jennifer and myself after the webinar. So thank you again. Today, we're going to be discussing the laws and responsibilities, the overview again of what the fair housing law is, protected classes and types of discrimination, disability and housing rights, source of income and gender discrimination, prohibited acts and harassment, accommodations and modifications, request process and responsibilities, and then we'll do the QA throughout, so we probably won't need to do the Q&A session after, but just in case it's there. All right, this is a very important time in the rental sales process, especially rentals heating up. So this is a great topic. And thank you again, Daniel and Jennifer, for joining us today. So Daniel, do you want to off and discuss, what fair housing law is and the goal and who must comply?
Sure. So the fair housing laws are basically the laws that govern the responsibility to not discriminate against anybody in anything having to do with the rental, sale, financing, really the operation of housing, and that includes specifically co-ops and condos. It applies to boards, brokers, real estate brokers, mortgage brokers, anybody who's involved in that process, in that in that aspect, and anything to do with the housing.
And then as far as, recent updates with the laws, can you maybe briefly just speak to that?
There's always updates, and they've made it more strict over the past several years. There's obviously been updates in terms of the rental restrictions, but the discrimination laws are constantly being updated on the state level. There's been changes. Their source of income is something that's now becoming more relevant. That was a big one. That came out of the old Section 8, well, not old, it still exists, but the Section 8 program. And really, it has more to do with landlords, but it can apply to co-ops and condos. But that was really how the program is, how the source of income got started, really. The landlords in rental situations weren't accepting Section 8, which defeated the purpose of the program. So they passed a law saying you couldn't discriminate against Section 8 or against any source of income, any lawful source of income. That was aimed at trying to stem that, and it applies to co-ops, condos, anybody who is where there's payments for the rental or payments having to do with your housing. You can't discriminate on the source of income. For co-ops, that is particularly important in the application process. That doesn't mean that you're not allowed to look at the amount of the income. It doesn't mean that you're not allowed to look at the source of the income. You are allowed to look at those things. You're not allowed to discriminate based on it. So they still have to meet the same financial requirements. But as long as the income is lawful, you can't discriminate based on where that doesn't mean that if somebody is not reporting income on their tax return with, but it's really for a different reason. They're really not being income that they're hiding, and they're not being. There are other kind of like bonuses and go off topic that can that do have considered. It always comes up in really a source. Usually gets asked.
I'm sorry, Daniel. I think you're coming in and out. I just want to make sure everyone isn't having problems, but hopefully the Zoom will get better in a minute. I think it's worldwide, but I heard what you were saying. Great. And then as far as protected classes and types of discrimination, can you share a little bit about that?
Sure. So there's the federal level, the state level, and the city level, and everybody has, and outside of New York City, it would be the county level. Um, and on the federal level, race, color, religion, sex, national origin, disability, familial status. The state level, it's all that, and marital status, age, sexual orientation, military status, gender identity, again, lawful source of income. And on the city level, citizenship, pregnancy, height, weight, criminal record is a new one. I should have mentioned that in terms of the new laws. I think you guys have already done a seminar on that, or you've spoken about that, but that's a big recent one, that you're not allowed to discriminate based on criminal record, and then also domestic violence victims. So those are the protected classes. The types of discrimination. So you have actual discrimination and perceived. Actual means the person is actually in that protected class. Perceived means that whether or not they're in that protected class, if you think they are and you discriminate against them based on your thought that they're in that protected class, that's still discrimination. It's not a defense that they weren't in that class. So for example, if you think that somebody is of a certain age, they're too old or they're too young, and you discriminate against them because of that, whether they are that age or not, if you thought they were 80 and you discriminated against them because of it, you treated them differently, it doesn't matter that they were actually 50 or 60 and just look older, it's still discrimination. So the courts are going to look at either one. If they're going to look at the fact that you discriminated based on your thought, your perception, that's just as much a problem as if they actually were in the protected class.
Right. And then as far as the criminal record, I know that is new. We did do, a webinar on it, but just as a reminder, can you just, give a quick summary on that?
So you're no longer allowed to even look at their criminal record during the application process. You can't until they're fully approved, interviewed, and everything. At that point, you can look at it, but there's limits as to what you can, the level of the crime, felony, misdemeanor, and then how long it stays on their record. And there's basically, you can't discriminate against them or refuse them on most of those bases. So there's a lot of limitations on it, and you can't really look at it during the application process.
Got it. Thank you. And then from a disability housing rights standpoint, what are some of the conditions? And I know that we do manage in obviously Manhattan, but as well as Westchester. Are there similarities, differences, and how are they affected?
So for the most part, it's the same in Westchester as it is in the city. The difference really comes in who's responsible for the costs of accommodations. But the in terms of the issues, mental illness, chronic illness, physical impairments. So recovering addiction is an interesting one. Somebody who is actually is presently addicted, that's not a protected class. If they are a recovering addict, that is a protected class. So that's an interesting one to keep in mind. And you can't deny the housing, or you can't discriminate against them because of the fact that they have a disability. So you can't deny an application based on wherever you are, New York City, anywhere in New York State, you can't deny the application based on that disability. They have different, the state, the city, the federal government, they all have different definitions, or they technically have different definitions. They're largely the same. And so they're largely the same. I don't really think I have to go through that. I mean, I can if you want, but all of those things, it's really anything that has to do with in something that impacts their daily life activities. So walking, working, thinking, breathing, sleeping, eating, caring for oneself, anything like that affects your ability to go through your daily life in a normal way. That's what's covered under the disability. And you can't, like I said, you can't discriminate against that in the application process. We typically advise not even asking about it during the application process, because it shouldn't have any impact on whether you're going to approve them. The fact that it could be anything from needing an emotional support animal to needing some kind of modification because they have a physical handicap or disability, whatever that is, you're not going to approve them or deny them on that basis. You can't factor that into your approval or denial. So we usually recommend not even asking it in the application process. When we have people that sometimes people volunteer it, they say, "Oh, I have an emotional support animal" or whatever. We generally, where we're in situations where we're processing the applications, we generally tell them to put that aside, and that can be dealt with after the application is either approved or denied. That way, to try to shield the boards. I mean, sometimes it comes out anyway, but as best as possible, either way, it shouldn't be considered at all.
What about though the interview process? If they come and at that point, they share that information.
Well, okay, so for the interview process, number one, you're already going to know by that point that they're financially qualified. Because if they're not financially qualified, if they don't meet your base qualifications, of financial, if you're a no smoking building, no smoking, like whatever those things are, if they're not meeting your base qualifications, don't interview them at all. Just reject them without the interview. So at the interview, yes, it's there's going to be some things that are obviously that are obvious to you, that you're going to be able to tell by looking at them that they have the disability. Um, and you just have to do the best you can. Don't ask questions about it. I mean, obviously, if they're talking about it, you can't stop them from talking about it. But don't ask specific questions about their disability. Just keep your questions tailored to just getting to know them and anything, whatever your normal questions would be for anybody else. And then that again, it just shouldn't factor into your decision one way or the other.
What about, so two things. What about for no smoking if someone needs medicinal marijuana, for whatever health reason, as an example? And then you mentioned again, if it's like a no pet building, but someone needs to have a pet, for medical reasons again.
Yeah, good question. So the medical marijuana, so just because they have a need for medical marijuana and they have the doctor's note and they need the accommodation, that doesn't mean that they have to smoke it. There are many other ways that they can get the medical marijuana, whether it's drops, in gummies, food, other edibles, things like there's many different ways that you can get it. So you can get the pills, you can get the benefits of it. You're meant to satisfy your medical need without smoking where it impacts somebody else. So you wouldn't be telling them if they made that request, you wouldn't be telling them that you're denying their request for medical marijuana. You're just telling them they can't smoke it. They could still get gummies, brownies, pills, drops, whatever, whatever the case may be. In terms of service animals and emotional support animals, that's complicated. The courts and the law sides on the right of a person that needs that animal to have it. And there's certain things you can ask. You can ask if the disability is not obvious, you can ask for an explanation. You're not allowed to require their request to be in writing. This is for any modification or any accommodation. And I can talk for hours on this topic, but so any accommodation, any modification, you need to ask for the least amount necessary to evaluate the request. And like I said, they don't have to put it in writing. We like to request that they put it in writing. Again, that's a request, and we think it's for everybody's benefit, because that way, if there is any question about it, about whether they made the request, what their request actually was, what did they give all the information that was needed. If it's in writing, there's really no question as to what they gave you and what they requested. If it's not in writing, then there's now this it's more ambiguous, and it's hard to say what they really said or not. So you can't require it, but you can request it. And then again, with animals, you're not allowed to, pretty much all the normal rules that you have go out the window. You can't require insurance, you can't require pet fees, you cannot restrict the breed, size, weight of the animal. There are certain restrictions, in terms of exotic or feral animals, for emotional support things. But we've seen, pot-bellied pigs, pygmy ponies. Those are some, rare ones that people get occasionally. Um, if somebody needs it for service animals and really for any modification or accommodation, if it's, like I said, if it's obvious, if they're blind and they need a seeing eye dog, you really don't need to ask them for the doctor's note. The doctor's note is just usually going to say, or it could be, for an emotional support animal, doctor, therapist, social worker, could be parent, could be friend, could be anybody really, but that has some knowledge of them and their treatment. And it's not that hard anymore to get a note from your doctor. It's really rather easy. So it's not anything that, it used to be when they first started happening and it became popular. People would go online and they would get these online doctors to therapists to write them notes and whatever. It's so easy now to get a note from your doctor or your therapist or anybody that's not even really much of an issue anymore. But um, so um,
Can I ask, can you make them go through certain entrances? Can there be restrictions? Like, we're a no pet building, but you can go out the back entrance, or is there just everything can go from there?
everything goes. They have the right, and this is with that, and it's with any accommodation, any modification. They have the right to the full use of the property. Modifications, it gets a little tricky because sometimes somebody wants a ramp, or something like that, and those type of things have to be done per the building code. So there's, to do a ramp, it's supposed to be 1 inch of height for every foot of depth. So that if you have, 6 steps and each step is 8 inches, whatever, that could end up being a really long ramp. So it might not fit, especially in the city where sidewalk space can be at a premium in some places. It might not always fit to be possible to do a ramp. But if you can do one, that's kind of the first part of the test, and then financially can be an issue as well. Um,
And
so, but
that's on the building, right? So say someone,
yeah,
needs a ramp, and as you mentioned, currently there is none, and there's 6, staircases. This person, applied to have maybe a co-op. What does a building have to do as its next steps to demonstrate good faith?
well, so there's two things. I mean, it depends. There's a lot of thought has to go into the type or analysis. Part of the analysis is the type of building. If you're talking about an elevator building and you're only talking about the entrance to get into the building, then it depends on what whether that ramp in the front can be done per code. Is there enough space on the sidewalk to have a code compliant ramp? Or if not, what else can you do? You can't just say no. You have to make a good faith effort to negotiate with them that even if you can't do specifically what they're asking, is there something else you can do? Um, it gets a little more tricky if it's a walk-up building, because then it's not just a ramp. Obviously, you can't have a ramp inside the building. They might request one of the chair lifts that goes on the wall and whatever, that type of situation. Again, that can be tricky because the staircases are supposed to be a certain width so that if a stretcher from an EMT has to get up and down, that it's wide enough they can do it. And a lot of times, or there are times where with the chair lift, that reduces that width. So now a stretcher can't get up and down easily. So that can be an issue. But again, you have to negotiate with them and try in good faith, try to see, we can't do what you want, but is there something we can do to help figure out this situation?
So they can't be denied, unfortunately, it's not by code. So unfortunately, that's not going to work. You can't say something like that. In the best case scenario, it sounds like would be to consult to your building's attorney and figure out what the best response is. It shouldn't just come from you, a board member. It should really, to be protected, should come from an attorney. Am I correct?
You definitely should discuss this with your attorney, and look, in a lot of these situations, you may have to get an engineer to help you do this analysis also. They'll know what the codes are, what can legally be done, what can't legally be done. But yes, you should definitely talk to your attorney, get the right response. Um, yeah.
And then Jennifer, from an AKAM perspective, when we receive an application that, might require further investigation, how do you generally respond?
Well, it depends on what's being requested, but we would let the board know that we've received an application that has this possible accommodation as a request, and is there anything additional they would like us to request from the applicant so they can do a complete review.
Got it. Yeah, it just seems like, you'd want to make sure that as a board, you're obviously doing the right thing and acting in good faith. So from the sources of income, gender discrimination, obviously that comes up too. And it's, what are some of the protections that people have for this?
For the boards?
I would say from the applicant perspective.
From the for the gender discrimination for the applicants?
Sources of income, yeah.
Okay, so sources of income, I'll deal with that first. It's a little easier. So the sources of income, it's the protection is that the board is required to take all lawful sources of income equally. And they're not allowed to discriminate. If the person feels they're being discriminated against, they can file a complaint either with the, with on any of the level, federal level, state level, county level, city level. So that's really the protection for the person if they think they're being discriminated against. The reality is, in the Section 8 part of it for co-ops, it doesn't really, and to a lesser extent condominiums, it doesn't really happen because part of the Section 8 program is that you have to sign their agreement. They have like their own lease, but that doesn't work in a co-op because in a co-op, you can't just amend the lease unless you do it for everybody. And you have to have a vote of the shareholders typically to amend the proprietary lease or occupancy agreement. You have to have something like that. So it becomes hard for that particular part of it, it becomes hard. In general, with source of income, like I said, the protection is if they feel they're being discriminated against, if they feel that their application was rejected because of their particular source of income situation, then they can file a complaint. In terms of the gender discrimination, it's pretty much the same thing. If you feel you're being discriminated against by gender, anything like that, then again, same thing. They would file a complaint, and we see these regularly. So it's not something that's rare. Complaints, whether source of income, other application discrimination, whether it's gender discrimination, whatever the reason, the State Division of Human Rights, and the city and the different levels are kept busy. And my advice to the boards would be, don't ask for pronouns on your application. Don't refer to them. It's kind of and anything that you learn in the application process is a don't ask, don't tell. They haven't, there's really, that's the best protection for the boards is don't ask it. Anything you learn, don't tell it. And if the person makes the request to you to use a particular pronoun or to address them, or they want to be referred to in a certain way, allow them. If you have some common bathrooms, you have to allow people to use whatever bathroom they identify with. Unfortunately, you can't have gender specific bathrooms anymore.
Are there any examples where you were working with the board or because you mentioned you've seen it, where people might have thought that they weren't being discriminatory and it ended up being, a discriminatory action without them realizing it, just from, a buyer beware?
I've had a couple of different situations. I had I've had many situations where people filed complaints against my boards. There was one where the board rejected. It happened that the same person was trying to sell their unit for their co-op for like a year and a half, and every applicant they brought wasn't financially qualified for like a different reason. So the seller brought a discrimination complaint against them. claiming that they were discriminating against the seller, because of the seller's ethnicity, and that's why they wouldn't approve the seller's potential buyers. That ended up getting resolved. The seller eventually found a buyer, and then that ended up getting resolved. I had another one in a co-op where the buyer was rejected, and he was convinced that it was because of his ethnicity and his sexual orientation. And even though in this particular case, they hadn't even met, they didn't interview him. They had no idea. And they had a very specific formula, but he was convinced because his bank was telling him that his debt to income ratio was fine, how they did it, even though that wasn't the same as how the board did it. Eventually we had to go through the whole process with the Human Rights Commission, and we eventually were able to show them how the board did it and convince them. And we had the board's notes from the time that they did the calculations to prove that this is how they did it and that was the only reason he was denied. So it worked out for them, but it does happen. I've had a few different situations like that with complaints. So.
What are your thoughts on addressing people with their professional introduction, like a doctor or Mrs. or Mr. used to be on applications? Do you recommend that no longer happen?
I would not put any, I wouldn't put any of the pronouns or anything like that on the application. It should just be name, first name, last name, whatever. There's usually a place for their job, so you'll know what their profession is. You don't have to address them by that. I wouldn't, there's just not really a benefit to it.
Okay, thank you. And then for the next topic, I think we've talked about the sources of income, what's legal versus illegal. What are some, examples that maybe are prohibited for, harassment, refusing to negotiate discriminatory terms, especially when there's false advertising, maybe. And that I think was in the article a while ago about a few brokers turning people down just based off of their inquiries because they had vouchers. I don't know if you recall that. And then, retaliation. I don't know if you can just speak briefly on those terms.
Yeah. Well, the voucher things, that gets to like the Section 8 thing, that gets to the source of income. Harassment is an interesting one because that's that's anything. So, okay, the one thing to be aware of for harassment is this is one of those areas where, and it's true of that, it's true with any type of discrimination. The boards are responsible not just for themselves, but their managing agents, their super, their porter, any of their staff, any contractors that they bring onto the site, onto the property, all those people, anybody like that they bring on, they're responsible for those people. So if those people harass somebody or discriminate, anything like that, the board is responsible. So the board can't just say, well, it wasn't me, it was the managing agent. The board's still responsible for that. So that's something to keep in mind. It comes up, it tends to come up a lot with buildings where you have a super or a porter or somebody that gets involved in a relationship with a unit owner or a shareholder. You can't really prevent it. You just have to really make sure your staff is careful. I think in some places there's mandatory sexual harassment trainings that even if it's not mandatory, it's a good idea to have your staff take it. And if you get a complaint, you have to treat it seriously. You can't just shrug it off. If it's a union building, get the union involved. That's the best thing I can tell you, because you will be, the board is responsible. If there's a discrimination complaint or a harassment complaint, the board's going to get named also.
And then briefly, how is the board protected from being named? Obviously, there's insurance, but how does the board get protected?
So the problem with the insurance is the insurance will pay for your defense. It will not usually pay with discrimination cases. It will not pay for the damages. So yeah, it'll pay for your defense. Now, the way to get around that a little bit is if you settle it, a lot of times the insurance company will throw in some money to settle it so they don't have to keep paying for defense costs. The best way to get around it is just try to make sure that your staff is educated, that everybody's educated and they know what you are allowed to do, what you're not allowed to do, what is discrimination, what's not discrimination. And if you're not clear on it, if you're not clear on a question to ask, if you're not clear on if something that might or might not be discrimination, if there's even a shadow of a doubt in your mind, ask your attorney. I mean, that's why they're there, so you can ask them and give them that hypothetical, and say, what should we do? Is this discrimination? But that's the best thing you can do, is ask the questions in advance so you protect yourself. Use that resource and make sure that everybody is educated, and as best you can. You're not always going to be able to prevent those relationships and things like that, but you can do your best to try and to make sure your staff is smart about it.
And then what are some discriminatory terms or advertising that maybe people aren't aware of that they're doing that could have negative results?
Um, refusing to negotiate with people, or it's a lot of that goes to the brokers. So when brokers steer people towards a particular area, or they try to convince people that they're not right for a particular building, it's setting different terms for one group of people versus another, with source of income, saying that, trying to have a policy that, people that have certain sources of income, if they're getting assistance, then they can't use certain facilities or, amenities or whatever. So those things are things to be aware of. Any terms any terms that you hear in the public that you think could be discriminatory, don't use them if you're not sure.
What about, this sounds silly, but parents purchasing for children is a very common thing that happens in New York City. Is there any way to make that sound like it is, you're discriminating against someone because that's their avenue of, financial capability?
Well, I mean, so it's so you have to be careful about not discriminating based on family status, but there is a difference between that and between the person who's residing there not being a shareholder and the shareholder not residing there. So as long as you have a policy that you're going to apply evenly, regardless of whether it's a parent doing it or a friend doing it or something else, if that's your policy, then that's different. So there are ways to protect yourself. There's also, if you can get the votes, there's also ways of amending the proprietary lease to clarify the language, so that it would make that more difficult. There's case law on both sides of it, depending on whether you're in the first department or second department, that talks about that. But it's, so it is an issue, but there are definitely things you can do. Again, talk to your lawyer. The problem is with a lot of these things, there's a lot of stuff in the discrimination area that's case by case basis. It's hard sometimes to give a one size fits all answer. But in this case, that the parent buying for the child, it can be a problem. And I mean, there are ways around it. If you want to have the shareholder be there and you don't mind, you can have a guarantor. I mean, there are situations, there's things you can do which would allow maybe the child to buy it if the real concern is that, they didn't think they would qualify, so they were having the parent buy it instead. There are policy things that you can do to try to get around that so that you don't have that situation, the dump and run, whatever type situation.
Got it. Yeah, because I'm sure that comes up a lot. And also, just if someone is handicapped and they need their, family's assistance, then I'm sure, that could also be tied together. And then as far as, retaliation, what are some, examples, maybe just that, again, I think it's more protecting boards, realizing that they might be doing something they don't realize is potentially damaging to them.
Yeah. So the retaliation is, if somebody if somebody thinks that you discriminated against them and they bring a complaint against the board, and the board defending the complaint, and the board is convinced that they didn't do anything wrong. If the person is now behind on their maintenance, or if the board is just annoyed that the person brought this complaint that they now have to deal with, and the board decides that they've had enough and they're going to bring a holdover, they're going to bring a non-payment that they wouldn't have otherwise brought because, they're fed up, that's retaliation. When you take an action against somebody just because they brought the discrimination complaint against you. And whether or not they are successful on their original underlying discrimination complaint is irrelevant to the harassment complaint. So their discrimination complaint could have absolutely no basis, but if you did something retaliatory, if you brought a non-payment against them when they were only 1 month behind, and usually you don't bring it against people until they're 3 months behind, and you did it because you were annoyed at them because you had to deal with this discrimination complaint, that's retaliation, and that can be filed and considered its own separate cause of action that they can win on, whether their original complaint had merit or not.
Understood. Thank you. And then that kind of speaks to accommodations and modifications that are expected. So can you just go through that if you don't mind? Thank you.
Yeah. Can you say that again?
Oh, I was going to say, so that speaks to accommodations and modifications. Just some examples and what you're expected to do and when.
So, okay, so the first thing with accommodations and modifications, I always like to just define it first because I'm not sure how much people know what the difference is. An accommodation is a change to a policy change, like service animals, making exceptions to your normal rules, allowing service animals or emotional support animals, like you said before, in a no pet building. Sometimes somebody might need a parking space closer to the building, or a preferred parking space. Or if there's a wait list, they might need a parking space and they might need to jump the wait list. And things like that, submitting an application a different way, or adjusting their maintenance or common charges payment schedule based on when they get their assistance. Those are all those are accommodations. Modifications is a change to the physical structure of the building: ramps, chair lifts, wider doors, bathroom grab bars, lower kitchen cabinets, automatic doors into the building, things like that. Anything that modifies it. In New York City, the cost of whatever it is on the board. It's on the landlord or the board. There's a little difference with a condominium because it's technically supposed to be on the owner. So with the co-op's the owner of everything. It's on the co-op. With a condominium, it's a little different because the condominium doesn't own the actual unit. So the unit owner owns the unit. So anything that the unit owner owns would be on the unit owner, but the common areas that the condominium owns would be on the condominium.
So can you walk us through when you're expected to do what? Because so you receive an application and the request is that, someone has a wheelchair and your building doesn't currently have a ramp. When are you expected to provide that accommodation? Are there steps the building should be aware of, or?
Okay, so let's start out with, you shouldn't just sit on it. Like, you can't just sit on it and hope it goes away. But when you get an application for, so if you're talking about a purchase application, usually I like I said before, I try to decide those things separately because I don't want there to be any inference or implication that a rejection or a decision either way was based on the fact that they had also requested some kind of accommodation or modification. In terms of the request for the accommodation or modification, if it's an accommodation, it's a rule thing. So it shouldn't really take you very long. I mean, that should be pretty easy, assuming they get you everything they're supposed to get you, which is really not that much to determine whether they need the accommodation. If you're talking about a pet thing, service animal, emotional support animal, like I said before, if it's obvious, then you don't really need to go any further in terms of the need portion of the analysis. If it's not obvious, you ask for their note letter saying the need, detailing the need, and then and that's pretty much it. Once you have that, you say, okay, you need, we approve it. Then you can ask for a vet letter, showing that they have their shots, that that the shots for the animal are up to date, all that stuff. But that doesn't really go to the necessity. For parking space, it's going to be even less. I mean, you should be able to figure it out, and generally it shouldn't be that complicated. If somebody has a need for a parking space, if they're handicapped and they need a parking space in the building, you might have to give them that parking space. And
Like
somebody
a
else.
bigger example, like altering a staircase or, you know,
Oh,
having
for the
to,
modifications?
yeah.
Yeah, so for modifications, um, again, that's gonna take a little longer, but as long as, you know, and I think there's some kind of understanding that boards don't necessarily meet that often, but you know, you should get on it right away. If it's something that's gonna need an analysis by your engineer, you know, forward it to your engineer right away and make sure they're on top of it. And, you know, it could take a few weeks, depending on how big a deal what they're talking about is. It could take a few months. But you know, because anything with construction is not always going to be quick.
And during the
But I think you're
process, is that application in limbo? Like, are they in a holding pattern until that accommodation or modification is made, or are they closing on their unit?
well. Again, I treat it separately. It's up to them whether they. I mean, you know, we would approve the application to purchase independent of any request for modification. So if or accommodation. So either one, when they request, when they're doing their purchase application, that's on whatever the normal timeline is that they have to go through. Separately, they then ask for an accommodate, you know, modification. That could take longer. When you know, but in terms of the closing, that's up to them when they want to close. We, you know, in co-op, you've approved the application, they can schedule with the transfer agent, and then if they need a modification or accommodation, you know, that might be separate. If they want to wait, that's, you know, my feeling is that that's up to them. But you can allow them to close. You can't stop them from closing. It's, you know, you can, they're permitted to close as quickly as they want. You know, they're really independent of each other.
And then as far as demonstrating that you're doing the work to provide that reasonable modification, is there a timetable, a schedule you have to provide, or, you know, it's just in your due timing?
There's not really a specific time frame. It's not like in Westchester, there's timing on when you have to review the applications. I know that doesn't exactly exist in New York City. But there's not the same kind of fixed deadlines for when you have to respond. But I think it's kind of common sense. I would I would acknowledge to them as soon as you get their request. I would send something to them saying, we acknowledge receipt of your request. We acknowledge receipt of your request. We are analyzing it and we'll get back to you as soon as possible. So something just simple, basic like that. That'll, you know, that's the acknowledgement so they know you have it. And then, you know, forward it to your engineer if it's something that needs that. And just keep the paper file so you know, so you can document. You acknowledge, you know, when you got it on this day. You acknowledge to them immediately that you received their request. You then went to your engineer on this day and you're waiting to hear back, whatever. And then, you know, look, if you don't hear anything back from your engineer in a few weeks, follow up. You know, keep, you know, just kind of keep on top of it. And then from your engineer, you'll be given an idea of, you know, what you can do, what you can't do. Then you can have that conversation with them, having to do with, you know, we think we can do this, or it's not up to code, or it's, you know, this, yes, we can do this ramp, but it's a construction project, so we have to bid it out. We have to get the 3 bids, you know, whatever. And if it's requiring concrete, you might not be able to do that in the winter, you know. So there might be factors that will affect the timetable of when you're able to complete it based on the type of project that they're talking about. And what's involved, but that, you know, that's kind of separate, that the closing itself doesn't have to wait for that.
And then are you expected to make the same accommodation or modification for a rental application or renter versus an owner?
Yeah, the short answer is yes. Anybody who is residing there, if you allow rentals in the building, you know, then it's, you know, sublets or whatever, you allow sublets and somebody's there and they need an accommodation or they need a modification, then yes, short answer is yes, you have to give them the same.
And then the same I expect is if you are residing in a building, you're either an owner or a tenant, and then all of a sudden you have a change in lifestyle and now you need to make these requests, you have to also comply.
Absolutely. And I would say actually, that's the more from what I see, that's the more common way that it comes about is is people, have been there a while. Now they have lifestyle changes, whether it's a ramp, whether it's something in their unit, whatever it is. I think I see that a little more commonly. Um, I mean, the dog thing has taken on a life of its own with the service animals, emotional support animals. That's these days that's become people want an emotional support animal, they find a reason. But yeah, whether they're if they're an existing person, same process, same policy applies. Yeah.
I was trying to mute myself. That's great. This is very helpful. And then Jennifer, from an AKAM perspective, I imagine we are, when people apply or request these modifications through the transfer department, we're handling this as Daniel recommends, right?
Correct. And we would loop in the manager for the property at that time as well.
I muted myself again. I appreciated your time today, Daniel and Jennifer. This has been really, helpful. Is there anything that, people need to think about when it costs, when you're thinking about the process for responsibilities or, how to make sure, you kind of spoke to this earlier, Daniel, making it minimally invasive, not really kind of bringing up topics that you think you're going to get in trouble for later. Can you give some advice on that?
Yeah, I think so. Two things, like we said before, definitely ask your attorney, ask your professionals, that's why you have them, get their advice ahead of time before you have a problem. It'll be less headache and better in the long run. So that's the first thing. Also, have a policy for everything. Have a policy that you're going to apply evenly. So especially with discrimination, even if it's, in applications, even if it's as simple as we don't discriminate, but, have a non-discriminatory policy, apply it to everybody. If you make a change in your application process, if you make a change in your financial criteria, don't do it for a particular application, don't do it for a particular person or class of people. Just make sure that whatever change you make a policy and apply it the same to everybody.
Good advice. Someone has a question. What about unit door handles? The owner is responsible for the cost in their building, but the building sets the standard. Can the board decide that all handles will be upgraded to ADA compliant and charged back to the owners?
Okay, so let me preface this by saying I would really need to see I'm not clear on whether we're talking about a condominium or co-op. So if it's a condominium, I would need to see the declaration and bylaws to be sure. If it's co-op, I would need to see the lease and the bylaws to be sure. Generally speaking, yes, I think the building could do it. Whether the building does it and absorbs the cost or charges it back to everybody is kind of the same thing. So, you're all paying for it. So whether or not, you add it to everybody's bill or just factor it into your maintenance and common charges. I would tend to do it that way because there'll be less headaches and less, why have the extra line item on the person's bill? So, and then there's no real question about it. So I would say you can, if the board decides they want to take on that responsibility of changing all the door handles to make them ADA compliant. I think you can do that. And if you want to set that standard and you want to do it, you can do it. Again, without knowing the person's particular building and their particular situation and the personalities and whatever, a little hard to totally comment. But as a general, like I said, generally I would avoid the headache of making it a line item and having people say, well, I didn't want to do it, so why should I have to pay for it? Just factor it into the maintenance and then everybody's paid for it.
Got it. Thank you. Yes. Just as a reminder for everyone, we are able to provide a copy of the presentation. All of our presentations sit on our company website, and they usually are up there about 3 days after we posted, so today. But you can also feel free to reach out to any one of us, and we will definitely happily send you that presentation. As far as a discrimination policy, Jennifer, is this something that is posted on domicile, or is it because every building is different, that is not a thing?
Yeah, I cannot think of a property where we have hosted a discrimination policy. But if a building wants to do that, then we certainly could include it there under the documents that applicants are able to view, or even a link to it.
Got it. And then as far as just in general, you know, buildings have their own policies, so it's not really a template, right?
Correct, yeah. Every building has its own policies for the way that they review applications in general, and the discrimination policy is part of that.
But if you have questions about your policy, it would be great to contact an attorney such as Daniel Finger and or you know, your building's attorney, and get more advice on that, because it certainly seems more important than ever to have that in place and to make sure that you're up to date to protect yourself. Really appreciate your time, Daniel. It's been really helpful and informative, and thank you, Jennifer, as well. And thank everyone for joining us today. Have a wonderful day and stay well. Thanks. Bye.
Thanks a lot.
Thank you.